The class plaintiffs claim Google invaded users' privacy under the California Constitution and the state tort of intrusion upon seclusion, meaning the intrusion into a private place, conversation, or matter in a highly offensive manner. Google has agreed to stop using the cookies for Safari browsers and pay $5.5 million to cover class counsel's fees and costs, without directly compensating any class members. Again, without directly compensating any class members. The class members are the plaintiffs. The court misstated the nature of Frank's objections, then dismissed the issue in a single sentence with no analysis, holding that no conflict of interest had undermined the selection of CPRE recipients. This is not the scrupulous examination required of a court acting as a fiduciary for absent class members.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
So the United States Court of Appeals for the Third Circuit has thrown out the Google cookie placement consumer privacy litigation settlement because it apparently does not benefit the class plaintiffs. And let's find out what this is all about. And we're going to go over something that I don't even really understand that much. The doctrine of CPRE, which is spelled Cypress, but it is actually pronounced CPRE. We looked this up because I'm gonna get this right. Cases with many plaintiffs, few to none of whom will sue solely for themselves. Gee, we don't know anything about that in DMCA law. Because the costs far outweigh the benefits, frequently result in class actions under Federal Rule of Civil Procedure 23. Prerequisites are having 1. So many class members that joinder is impractical. 2. Questions of law or fact are common to the class. 3. One or more representatives whose claims or defenses are typical of the class. 4. Representatives who will fairly and adequately protect the interests of the class. Besides these prerequisites, a class action must satisfy one of the subsections in Rule 23b. As pertinent here, subsection 2 provides that a class action may be maintained if the requirements of Rule 23 are met, and the party opposing the class has acted or refused to act on grounds that apply generally to the class, so that the final injunctive relief or corresponding declaratory relief is appropriate, respecting the class as a whole. For the first time, we review an order approving the settlement of a class action certified under Rule 23, where the only benefit received by the class was defendant's payment of a CPRES award to organizations the defendant approved. And here's where we're going to explain a little bit about CPRES. The term CPRES is derived from the Norman French expression CPRES comme possible, which means as near as possible. The doctrine originated in trusts and estates law as a rule of construction used to preserve testamentary charitable gifts that otherwise would fail. So there's where we're going to get complicated. These are testamentary, which means after death in a will, charitable gifts, which is a gift to a charity or charitable organization, and that gift in the will has to fail. When it becomes impossible to carry out the charitable gift as the testator or the giver, the deceased person intended, the doctrine allows the next best use of the funds to satisfy the testator's intent as near as possible. We can't ask the deceased person what they would have wanted if they can't have their first choice. They say, let's give $1 million to the local animal shelter. Well, it just so happens the local animal shelter is closed for permanently just before the person dies, and a new one's not being opened. So you can't give the $1 million to the animal shelter. Well, the court might decide that it's appropriate to open an animal shelter in place of the closed one and to use the $1 million for that. Is that what you said in your will? No, but it's darn close, and there wouldn't really be another way to handle it. Like, what else would happen to your money? You would just hand it to somebody and they'd go spend it in some other way? That's much farther away from the intent of your will. Well, how does this apply to the Google settlement? Let's figure that out. The defendant, Google Inc., created a web browser cookie that tracks an internet user's data. For some Safari or Internet Explorer browser users, a cookie may have operated even if the user configured privacy settings to prevent it from tracking data. The class plaintiffs claim Google invaded users' privacy under the California Constitution and the state tort of intrusion upon seclusion, meaning the intrusion into a private place, conversation, or matter in a highly offensive manner. In a disputed Rule 23 class settlement, Google has agreed to stop using the cookies for Safari browsers and pay $5.5 million to cover class counsel's fees and costs, incentive awards for the named class representatives, and CPRE distributions without directly compensating any class members. Again, without directly compensating any class members. The class members are the plaintiffs. The 6 CPRE recipients are primarily data privacy organizations and all must agree to the use of funds to research and promote browser privacy. In addition, Google would obtain, among other things, a class-wide release of all class member claims, including for money damages that did or could stem from the subject matter of the litigation. The lone objector, Theodore H. Frank, challenges the district court certification of a settlement class and the terms of the approved settlement. He argues that the CPRE money properly belongs to the class as compensation. He asks us to vacate the settlement as unfair and require direct distributions to class members before resorting to CPRE awards. In the alternative, if direct distributions are truly infeasible, he asserts the class should not have been certified due to inadequate representation. Frank also challenges the party's choice of CPRE recipients because of their pre-existing relationships with Google and class counsel. We believe that, in some Rule 23b2 class actions, a CPRE-only settlement may properly be approved, but here, the district court's cursory certification and fairness analysis were insufficient for us to review its order certifying the class and approving the settlement. The settlement agreement's broad release of claims for monetary damages and its designation of CPRE recipients are particularly concerning. We thus vacate the order approving the settlement and remand for further proceedings consistent with this opinion. So we're going to skim a couple sections of this and try to get an understanding of what's going on here and see if we can tease out the interesting parts. We outlined the facts underlying the class's claims in re Google Inc. Cookie Placement Consumer Privacy Litigation, 3rd Circuit 2015. In brief, news broke in early 2012 that a Stanford graduate student had discovered Google's DoubleClick.net cookies were bypassing Safari and Internet Explorer privacy settings and tracking internet user information. Google settled the resulting Federal Trade Commission and State Attorneys General lawsuits, agreeing to cease the practice and to pay a combined $39.5 million in fines, though admitting no past acts or wrongdoing. Plaintiff internet users also filed claims against Google that were later consolidated into a putative class action. The class complaint alleged violations of federal privacy and fraud statutes, California unfair competition and privacy statutes, the California Constitution's right to privacy, and that state's privacy tort law. It sought injunctive and monetary relief. Google moved to dismiss, and the district court granted the motion in full. On appeal, we affirmed the dismissal of all but the California constitutional and tort claims. On remand, the parties began discovery. Then they sought to avoid further litigation and began mediation before a former federal judge. With the help of the mediator, the parties agreed to a settlement and simultaneously moved for certification of a Federal Rule of Civil Procedure 23b2 class and approval of the settlement under 23e. The latter states that claims, issues, or defenses of a certified class may be settled, voluntarily dismissed, or compromised only with the court's approval. It also lays out the procedures that apply to any such settlement, dismissal, or compromise. The proposed settlement defines the class as all persons in America who use Safari or Internet Explorer web browsers and visited a website from which DoubleClick.net cookies were placed by the means alleged in the complaint, excluding individuals who had already obtained relief from Google or submitted a valid and timely request for exclusion. In sweeping language, the settlement would release all class member claims, including for damages that did or could stem from or relate to the subject matter of the litigation. In exchange, Google would be required to assure it had implemented systems configured to abate or delete all third-party cookies that exist in Safari browsers. As noted, it would also pay $5.5 million in fines to be divided among the settlement administrator, class counsel, the named class representatives, and CPRE recipients. The settlement agreement requires both parties to agree to the CPRE recipients. The class must propose up to 10 options, and Google may strike any for a non-arbitrary reason and request placement. The class must propose up to 10 options, and Google may strike any for a non-arbitrary reason and request a replacement. The chosen recipients must agree to devote the funds to promote public awareness and education and/or to support research development and initiatives related to the security and/or privacy of Internet browsers. The parties ultimately agreed on 6 recipients: the Berkeley Center for Law and Technology, the Berkman Center for Internet and Society at Harvard, the Center for Democracy and Technology, Privacy and Data Project, Public Council, the Privacy Rights Clearinghouse, and the Center for Internet and Society at Stanford University. Neither Frank nor the district court were privy to the selection process. The settlement of a putative class action requires the approval of a district court, both for certifying the class and for determining whether the settlement is fair, reasonable, and adequate. We have provided guidance on the factors a court should consider in deciding whether to approve class action settlements, most notably the Gersh factors and the prudential factors. Not going to go over them. They're more or less listed here on your screen right now. Where, as here, the parties seek simultaneous class certification and settlement approval, courts should be even more scrupulous than usual when they examine the fairness of a proposed settlement. This heightened standard is designed to protect the interest of all class members. Some class action settlements also require the sending of notice to members of the putative class. Before approving the settlement of a class action certified under Rule 23b3, which is primarily used to pursue money damages in class actions, a court must direct to class members the best notice that is practicable under the circumstances, including individual notice to all members who can be identified through reasonable effort. For class actions under Rule 23b1, which is often used to pursue class actions involving a common fund or stakeholders, or for 23b2, which I think is the one here, which is used to pursue injunctions, the rules do not impose the same mandate or notice. Rather, they state that the court may direct appropriate notice to the class. Of course, regardless of what these rules say, the procedures for class action settlement, including the notice procedures, must also comply with due process requirements. Due process requires notice and a meaningful opportunity to respond, etc. So even if the law says you don't require notice, you might still require notice if someone like me is just finding out about this for the first time and never heard about a class action settlement of the Google cookies thing because apparently they never sent one. The district court preliminarily certified the class for settlement under Rule 23b2. Following a notice period, the court received 50 exclusion requests and 1 timely objection. Frank, the sole objector, asserted that either the settlement was unfair because it improperly preferred CPRE over direct compensation to class members, or in the alternative, the class could not be certified if direct compensation was impossible. So what's the court saying there? The objector, this Mr. Frank, asserted that either the settlement was unfair because it preferred CPRE payments over direct compensation. Remember, CPRE was payments going to those 6 organizations, and they were going to be directed to spend the money on privacy in browsers advocacy. Nobody else got any significant money. None of the class members got any money for the violation of their rights. And the court's about to go into how CPRE really isn't what you turn to until after those class members are compensated, not before. So let's keep going. He further argued that the C-Prey recipients raised a conflict of interest concern because class counsel was on one recipient's board and Google was a regular donor to 4 others. Finally, Frank challenged the attorney's fees, an issue he does not raise on appeal. To determine whether a settlement class could be certified, District Court conducted a hearing and heard arguments from the parties. Following the hearing, it issued a short opinion and final order approving class certification and the settlement. In its opinion, the court correctly noted that it could certify a class only if the requirements of 23A and one prong of 23B was satisfied. It stated that no objections had been filed challenging class certification, then in 3 sentences explained why all the requisite factors were met, without stating what type of Rule 23B class was certified. The court then reviewed the proposed settlement for fairness, reasonableness, and adequacy as required by Rule 23E2. That rule provides that if a class action settlement would bind class members, the court may approve it only after a hearing and only on finding that it is fair, reasonable, and adequate. The court here noted that a presumption of fairness applies to class settlements that meet certain criteria established in our case law, but it did not make factual findings related to those factors or hold whether the presumption applied in this case. It then applied the Gersh factors, remember above, in determining whether the settlement was fair, reasonable, or adequate. Though it spent only 4 sentences analyzing the entirety of Gersh's 9 factors, the court concluded that the record adequately establishes that they had been satisfied. It acknowledged additional factors to consider under prudential and in re baby productions antitrust litigation, but did not expressly apply them. Ultimately, the court rejected Frank's arguments and approved the settlement. It found that the nature of the likely compensation to the class members has always been complicated by the substantial problems of identifying the millions of potential class members and then translating their alleged loss of privacy into individual cash amounts. It further found that payments to absent class members would be logistically burdensome, impractical, and economically infeasible, resulting at best with direct compensation of a de minimis amount. De minimis means so minimum it basically doesn't exist. Because the C-Prey money would be used by preeminent institutions for researching and advocating online privacy to promote internet browser privacy, it held that the C-Prey awards bear a direct and substantial nexus to the interests of absent class members. In one sentence, the court noted Frank's objections to the pre-existing relationships between Google Class Counsel and the C-Prey recipients, but held no conflict of interest had undermined the selected C-Prey recipients. Frank timely appealed. And thank you very much, Mr. Frank. We really appreciate that. Frank raises 2 challenges to the proposed settlement's fairness, reasonableness, and adequacy. First, he argues the settlement, whose main monetary component is a C-Prey award, provides no marginal benefit to the class and therefore cannot satisfy the rule. Indeed, he asserts a C-Prey award is always inappropriate if some individual class members could be compensated through a claims or lottery process. Second, Frank challenges the selection of the C-Prey recipients due to their pre-existing associations with either Class Counsel or Google. We have identified 2 opposing interests a district court must weigh when reviewing motions for settlement-only class certification and approval of the settlement. First, we favor the parties reaching an amicable agreement and avoiding protracted litigation. A district court is thus to presume a settlement is fair if the negotiations occurred at arm's length, if there was sufficient discovery, if the proponents of the settlement are experienced in similar litigation, and if only a small fraction of the class objected. At the same time, a district court has an obligation as a fiduciary for absent class members to examine the proposed settlement with care. Remember, fiduciaries must act in your best interests, not in their own. This duty is heightened in settlement-only class cases, quote, where settlement negotiations precede class certification and approval for settlement and certification are sought simultaneously. We require district courts to be even more scrupulous than usual when examining the fairness of the proposed settlement. In settlement negotiations, the interests of class representatives or class counsel do not always align with the interests of absent class members. And prior to certification, class members may not know their claims are in litigation or that settlement negotiations are taking place. Yes, I did not know this was taking place. Thus, a district court's scrupulous review of the settlement terms is designed to ensure that class counsel has demonstrated sustained advocacy through the course of the proceedings and has protected the interests of all class members. These principles, combined with the legal analyses further described below, lead us to disagree with Frank that C-Prey-only settlements are unfair per se, which means basically always or automatically. In some cases, a C-Prey-only settlement may be proper, but we are troubled by the district court's cursory certification and fairness analysis in this case, and two features of the settlement discussed below compel us to vacate and remand. We have never addressed whether a class action settlement's monetary award may be given solely to a C-Prey recipient. In the usual C-Prey case, money from a class settlement fund remains after distributions to class members, perhaps because class members cannot be located, decline to file claims, have died, or the parties have overestimated the amount projected for distribution. In those cases, parties may seek to distribute to a non-party or non-parties the excess settlement funds for their next best use, a charitable purpose reasonably approximating the interests pursued by the class. C-Prey is generally preferred to escheating funds to the state, which is what happens when you don't have a proper will or something isn't designated to go to a recipient. It ends up going to the state. So if you die without a heir, your money goes to the state, to literally to the state of California or the state of Pennsylvania or whatever. And that's called escheating, or reverting them to the defendant because it preserves the class action's deterrent effect and more closely tailors the distribution to the interests of class members. Still, many federal courts, the media, academia, and even Chief Justice of the United States view C-Prey awards with skepticism. Among other things, they present a potential conflict of interest between class counsel and their clients because they may increase a settlement fund and with it attorney's fees without increasing the direct benefit to the class. A settlement whose only monetary distributions are to class counsel, class representatives, and C-Prey recipients, as in this case, presents the risk of a still greater misalignment of the interests. The settlement clearly benefits the defendant, who obtains peace at a potentially reduced cost, class counsel, who are guaranteed payment in the settlement, and the named representatives, who are given an incentive award in the settlement, while any benefit to other class members is indirect and inconsequential monetarily. Despite C-Prey's flaws, we held in the baby products case that a district court does not abuse its discretion by approving a class action settlement agreement that includes a C-Prey component directing distribution of excess settlement funds to a third party to be used for a purpose related to the class injury. Favorably citing the American Law Institute's guidelines, we held that C-Prey was appropriate where some class members were compensated directly and further individual distributions are economically infeasible. We left the door open for other permissible forms of C-Prey and nowhere addressed it in the context of a Rule 23b2 class. With this background, we now consider whether a C-Prey only settlement in a Rule 23b2 class can ever satisfy the fairness requirement of the class action rule, and if so, whether the district court abuses discretion in finding this particular settlement fair, reasonable, and adequate. Frank's central argument is that C-Prey awards should never be preferred over direct distributions to class members because the settlement fund properly belongs to individual class members as monetary compensation for their injuries. He proposes that the $5.5 million settlement fund is sufficient to fund either a claims process or a lottery distribution for the class, even though he acknowledges it would be impossible to pay every class member. He criticizes the district court's weighing of the settlement fund against the size of the entire class because even in billion-dollar security settlements where class members have suffered substantial losses, the parties do not know who each and every class member is and must rely upon class members to identify themselves and the size of their loss in the claims process. We know no ruling that requires district courts to approve only settlements that provide for direct class distributions on these facts. Indeed, Baby Products suggested the opposite. We reason that C-prey distributions are most appropriate where further individual distributions are economically infeasible, and decline to prohibit C-prey distributions in other situations, including where even an initial distribution to some class members would be infeasible. We also reaffirmed that settlement approval should be a practical inquiry rooted in the particular case's facts and procedural posture, as the Gersh and prudential factors reflect. Ultimately, the role of a district court is not to determine whether the settlement is the fairest possible resolution, but rather to determine whether the compromises reflected in the settlement are fair, reasonable, and adequate. Google argues that this settlement fund was never intended to compensate class members monetarily. It claims the fund enhances the settlement's deterrent effect by funding data privacy institutions that will work to prevent similar potential privacy invasions from occurring in the future. This rationale accords with the purpose of the Rule 23b2 structure. The Supreme Court has described this as a more traditional collective action because it assumes a single, indivisible, injunctive or declaratory remedy against the defendant will provide relief to all class members equally. A B2 class, therefore, does not involve individualized determinations of liability or damages, or even require that individual class members be ascertainable. Nor does certification require the greater procedural protections of B3 classes, such as the opportunity for individual class members to receive notice of the action. That sort of explains that. Or the opportunity to opt out. To certify a B2 class, a court must simply find that the party opposing the class has acted or refused to act on grounds that apply generally to the class, so that final injunctive relief or corresponding declaratory relief is appropriate, respecting the class as a whole. In other words, the class must be cohesive such that the members have a strong commonality of interests. Contrary to Frank's arguments, then, we see no reason why a C-prey only B2 settlement that satisfies Rule 23 certification and fairness requirements would not belong to the class as a whole, and not to individual class members as a monetary compensation. Direct monetary distributions typically would not accomplish the purpose of a B2 class. It is not an inherent abuse of discretion for a district court to allow a C-prey only settlement rather than random compensation, and possibly even overcompensation through a lottery of some B2 class members to the exclusion of others. This brings us to the settlement agreement. District courts are to assess the fairness, reasonableness, and adequacy of a C-prey award under Rule 23E2 using the same framework developed for assessing other aspects of class action settlements, namely applying the Gersh factors, applying the prudential factors, and also considering the degree of direct benefit provided to the class, which may include the number of individual awards compared to both the number of claims and the estimated number of class members, the size of the individual awards compared to claimants' estimated damages, and the claims process used to determine individual awards, which didn't sound like that lower court did any of that reasoning. In its opinion, approving the settlement agreement, the district court ran through the Gersh factors and held that all 9 were satisfied, but in a more perfunctory fashion than we are accustomed to reviewing on appeal, which is a polite way of saying that the lower court did it hastily and didn't provide the details that the appeals court needs. It also acknowledged the additional factors we suggested district courts consider in prudential, but did not explicitly apply them. In this context, we are not persuaded that the court sufficiently assessed the fairness, reasonableness, and adequacy of the settlement. In particular, 2 features of the settlement present concerns that were not adequately considered by it: the broad class-wide release of claims for monetary damages, and the specific selection of C-prey recipients. The settlement agreement purports to release all class member claims, including for damages that did or could stem from or relate to the subject matter of the litigation. This raises a red flag. Before the district court, class counsel acknowledged that the dismissal of all claims providing for statutory damages made class certification more difficult. That premise, in turn, shaped the structure of class certification and class notice. The parties sought to certify an injunction under 23b2, not a damages class under 23b3, as we've been discussing, and thus avoided the heightened certification and notice requirements that apply to the latter. Yet, having sidestepped these requirements, Google and class counsel nonetheless obtained for themselves anyway the precise benefits that a Rule 23b3 class gives to the defendant and class counsel, namely a broad class-wide release of claims for money damages for the defendant, and a percentage of fund calculation of attorney's fees for class counsel. The district court's failure to scrutinize this troubling aspect of the settlement agreement prevents us from reviewing its fairness, reasonableness, and adequacy. We also question and leave to the district court to explain on remand whether a defendant can ever obtain a class-wide release of claims for money damages in a Rule 23b2 settlement, and if so, whether a release of that kind requires a heightened form of notice under Rule 23c2b or due process tenets. The district court held that the proposed CPRE distributions are appropriately tailored and focused. It found the selected CPRE recipients to be among the preeminent institutions for researching and advocating for online privacy. Because this case is about Google's alleged circumvention of internet browser privacy settings, it concluded the proposed CPRE distributions thus bear a direct and substantial nexus to the interests of, we said that above. The court made no finding that the class's nationwide nature was reflected in the geographical scope of the CPRE recipients' work. However, the record shows they overlap. The promotion of better online privacy inherently has nationwide effects. In sum, on the district court's review, the proposed CPRE awards would be used for a purpose directly and substantially related to the class's interests. The record also reflects that the geographical scope of the class corresponds to that of the CPRE recipients. The court held that the proposed CPRE awards were fair, etc. Although other aspects of the analysis were unusually brief, the court did not abuse its discretion by approving the B2 class's CPRE structure. Yet, we are troubled here by the selection of the specific CPRE recipients. Frank challenges the selection of those recipients as unfair due to pre-existing associations between them and class counsel or Google. He asserts that Google has long ties to Stanford, is a regular donor and CPRE payer to the Berkeley Center for Law and Technology, the Berkman Center for Internet and Society at Harvard, the Center for Internet and Society at Stanford, and the Center for Democracy and Technology. One of the lawyers representing the class is also a board member of Public Counsel. We have not previously addressed when a prior relationship between a CPRE recipient and one of its litigants in a class action undermines the proposed settlement's fairness. Regardless of the relevant standard, however, the district court's treatment of the question warrants remand. It conducted no fact-finding, either through additional filings or an evidentiary hearing, to determine the nature of the relationship between the CPRE recipients and Google or class counsel. In its opinion, the court misstated the nature of Frank's objections, stating he takes the position that any relationship between a party and its counsel and a proposed CPRE recipient automatically disqualifies the proposed CPRE recipient. It then dismissed the issue in a single sentence with no analysis, holding that no conflict of interest had undermined the selection of CPRE recipients. This is not the scrupulous examination required of a court acting as a fiduciary for absent class members. We further hold that if challenged by an objector, a district court must review the selected CPRE recipients to determine whether they have a significant prior affiliation with any party, counsel, or the court. A settlement should not be approved as such a prior affiliation would raise substantial questions whether the selection of the recipient was made on the merits. The parties seeking settlement approval bear the burden of explaining to a court why the CPRE selection was fair, which may include describing the nature of any prior affiliations, what role, if any, each affiliation played in the CPRE selection process, and why these recipients are the proper choice. As always, where a court fears counsel is conflicted, it should subject the settlement to increased scrutiny. The vista view of this case is not pretty. According to the complaint, an internet behemoth with unprecedented tools for monitoring private conduct told millions of Americans it would not track their personal browser history, and then it did so anyway to profit from the data. Through the proposed class action settlement, the purported wrongdoer promises to pay a couple $1 million to class counsel and make a CPRE charitable contribution to organizations it was already donating to otherwise, at least one of which has an affiliation with class counsel. By seeking certification under Rule 23b2, the defendant and class counsel avoid the additional safeguards that apply to monetary class actions. One might think this would leave room for class members to pursue damages individually, yet that relief is foreclosed as well, as the settlement contains a nationwide release of claims for monetary damages that arose or could arise were there unauthorized snooping, presumably covering tens if not hundreds of millions of Americans. In this context, we believe the district court's fact-finding and legal analysis were insufficient for us to review its order certifying the class and approving the fairness, reasonableness, and adequacy of the settlement. We thus vacate and remand for further proceedings in accordance with this opinion. So I know that was long and difficult, but that seems like Google was really trying to get out of monetary liability for having put cookies on computers that it promised not to track. And then it's trying to get through this class action without having to pay the class members anything. That sounds like what's happened here. And then so imagine you're an attorney in the class action. You get to have everybody complete basically a settlement. You get to make everybody agree to a settlement, and then the class members who are you're supposed to be representing don't actually get anything, but you get paid, and these other companies get donations and you get paid, but the class members get nothing. So I didn't even know this existed, is how secret they've managed to keep this. And now I find out that I'm likely a class member, and maybe I can find a way to object. I don't know. We'll see. Now that I know it exists, maybe I can also find a way to object. Let me know what you think of that in the comments below. So that is our show. Thank you very much for joining me. I am Leonard French, your favorite copyright attorney. Do we have treats for dogs? Can I get a treat for a dog?
Elsa, treats.
There we go. There's a good boy. There's a good boy. Thank you very much to our patreon.com/LJFrench and sponsors.org/law supporters. Would you like some help with that?
Thank you.
Is that what you're trying to get at? Are you going to call him over? Is that what you're doing?
I'm calling her over. Come on, Pop.
Calling her over. Okay.
Pop.
At the $500 level in the month of August, thank you very much to Joshua Davis from TandaPay. We're making a video about his social insurance program. Thank you very much to our $50 plus supporters: John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Jan Negrey, Blackleaf, Spirit Bear, Daniel Perez, Snorre Wisotzky, NotMike, Joe Tyson, and King Macro. And thank you very much to the $5 plus supporters who are scrolling on the LED panel above me, and you'll all appear in the description of the videos below. I am Leonard French, your favorite copyright attorney. This has been Lawful Masses Wednesday, August 7th. Thank you very much for joining me. I'll see you in the videos that drop. Love you all. Bye.